each episode, we answer AI questions submitted by Texas lawyers in plain English with practical tips you can use today and clear guardrails so you can stay ethical and effective. Today's episode focuses on ethics. Could you tell us what, if any, are the requirements for disclosure to clients and others that the practitioner is using AI?
The question of is disclosure required to the clients? It's probably even more of a nuanced answer. I mean, looking at the disciplinary rules of professional conduct, I can't point to a rule that per se says, a lawyer always has to disclose the use of AI to a client. But I think, like many things, it's going to depend on the circumstances. It's going to depend on the specifics of the situation. And I'll give you an example. If it's impacting the fee structure, if they're seeking to be reimbursed for expenses they're going to incur for specific per usage AI program where they're charged per use and it's tied to that client's case and they want to be reimbursed, I think they need to let the client know on the front end and, get informed consent from the client. Confidentiality is extremely important in the, period, but specifically here in the context of AI use. And, of course, the lawyer has a broad duty of confidentiality under Rule 1.05 of the Texas Disciplinary Rules of Professional Conduct. There's a helpful opinion, it's number 705 from the Professional Ethics Committee for the State Bar of Texas that does talk about confidentiality. Questions like, where is this information going that I'm putting into this AI system? Is this a local system on my own hardware, or is it going to third parties? How's it being used? And of course, competence comes into play here. The lawyer really has to have a current understanding of the technology and the risks involved. Practically, it may just avoid issues to be upfront with the clients about how AI is being used and may reassure the client. So I think there's some potential benefit just being upfront with the clients. And then if the client asks, I think it'd violate the disciplinary rules if the lawyer lied when asked about how AI is being used. And if the lawyer's practicing in other jurisdictions, then they're also going to have to consider how those jurisdictions treat the subject.
The courts definitely differ on their rules and what they require lawyers to do. So that's super important to check.
I do think that lawyers are going to begin to have to disclose their use of AI in their practice to their malpractice carrier. I think that the risks that are associated with the use, or certainly the improper use, I think that's going to affect legal malpractice insurance coverage. And I think it's going to need to be disclosed if it isn't already.
We are going to be having another Ask a Human webinar on April 15th.